Good afternoon. We are live. Hello, everybody. Hope you're all doing well. So we're gonna give people a couple minutes to catch up and get in here because, yes, the judge finally did drop her response in the Richard Allen case. So I think it's time to go over it. I think it's a little more appropriate given this is actually kind of a big deal, and I have not had a chance to really read it yet. I do know that the Attorney General has responded. I'm probably going to hold off on that until Thursday, just because that's merely a that's not as important at this point. Jared says, is that a picture of the judge? Yes, that is Judge Gull. Yes, that is her in the thing. Saban says, Judge Karen would like to speak to the Supreme Court's manager. Yes. And J Rock says, late in practicing. Yes, I tend to be. Thank you. So I'm just going to say, hope you guys all have a case of the Mondays. But I hope your Monday hasn't been too bad so far. Hopefully it's almost over. Aaron says, I live in Fort Wayne and I'm sad. Yeah, this judge is your judge. So it will be, yeah, she's your judge. Josh Mo says, does Cleveland actually rock? Depends on the day. I mean, right now we're supposed to get like a gajillion feet of snow, and I don't think it's going to happen. And D. Marie saying, oh boy, what happened? So the judge had the Supreme Court of Indiana said, hey, you need to respond to this. We give you till the 27th. Well, today's the 27th, and that's not out of the ordinary. It's use all the time you have. I mean, these guys basically had a whole Thanksgiving break to prepare this too, so why not? That's actually not a problem for me in this situation. So we're going to give everybody another minute or two. We're probably going to get started here. Robert saying streaming to YouTube on a Monday. Yeah, I wanted to stream because this is kind of a big deal. I think this is definitely worth looking at. And I think this is, I think it's a very interesting thing here. So yeah, this is from Judge Gull. This is her and her people doing it. So wait, why is that not showing up? There we go. That's why I was wondering what the heck is there. So got done with everything else, and I wanted to get this going. I do want to say who was it in my Discord? Starving Pig, who got me all squared away on getting this, so I think it's perfect time to cover it. Zero Signal saying hello. Yeah, how are you doing? If you guys are new and if you're a new person to the channel here, my name is Sean Martin, also known as Potentially Criminal. I am an attorney in the Cleveland area, and I practice criminal defense mainly. Do a lot of other stuff as well, but this is I love criminal defense work, and we're covering the Richard Allen case. He's accused of murdering 2 girls out in Delphi, Indiana. They were murdered back in 2017. For some reason, he decided to talk with the police, and they arrested him back in November of last year. And he's been sitting there waiting to go to trial. Since then, there have been some twists and turns in the case. And back in October, the trial judge, Frances Gull, who's the lady in the picture in the thumbnail, booted his attorneys off the case. Since then, Allen and his attorneys have both been fighting tooth and nail to get back involved. So they've sought the Indiana Supreme Court to fix this. And now the judge is responding to that, saying why they shouldn't fix it. Let's see here. Amateur Kanai class says the fire in the Cuyahoga River keeps the snow away. Yes. Let's go, Brandon. Wow. Hey, man, it's good to see you. For $4.99, thank you very much for that. I appreciate the support. Is saying, if you're new to the channel, I'm the captain of the ship. Yes. Look at me. I am the captain now. Brandon saying this trial really singes your ball sack, doesn't it? The way it's being handled, yes, very much does. Very, very much does. RP saying, hopefully I'll talk about law. Well, no, we need to talk about why you... Well, never mind. I'm not going to do it. Not going to do it. We're going to be serious today. So let's get started. I think that's good enough. Been 5 minutes. All right. So here we go. And this is the Supreme Court of Indiana. It's in the Supreme Court of Indiana. There you go. It was filed today at 3:41. And there's nothing wrong with that. I mentioned this a little bit earlier. If you have a filing deadline, there's nothing wrong with taking all the time. I do that quite frequently. Obviously, you don't wait till like 4:25 and it's due, and the court closes at 4:30. But, you get done like an hour or two early. You take all your time. You really make sure it's good. You use every bit of time you can, especially in a situation like this. So I don't fault them for that. It's a state of Indiana, ex-rel Richard Allen. Okay. So Richard Allen is seeking a writ of mandamus, or writ of mandamus, or writ of mandamus, however you wish to call it. And he wants the court here to order that Judge Gull put his attorneys back on. He's also seeking a writ to kick the judge off the case, but that's a separate matter. And he is going against the Carroll County Circuit Court because it's being run by the Honorable, and the Honorable is just because she is a judge. She is considered the Honorable Frances C. Gull. She's called a special judge in this situation because the original judge in Carroll County recused himself and got out. And that probably was a good idea. We don't know why, but they did that. They appointed a judge. She is from Fort Wayne, Indiana, very far away from there. It's an original action from the court, and this is the trial court number for Carroll County here. Doesn't really matter, but I wanted to give you guys an idea of what that is. So she is the respondent, and this is respondent's brief in opposition. So she's opposing the relator's verified petition for a writ of mandamus. And she did hire her own attorneys. And she has her table of contents here. And here's obviously your argument. You lay out your bullet points. You lay out your headings. And she lays out a couple. Obviously, none of these are going to be, oh, wait, guys, you're right, I'm wrong. She's going to find that. Now, all of this is then a conclusion, a statement of the word count, and a certificate of service. And then here's the table of authorities. These are all the cases she cites. This is actually a pretty girthy one here. So very, very interesting. I didn't get to read through all these yet. Well, I haven't read through any of these yet. And she mentions a couple cases. This one right here is one we are going to talk about. Strickland v. Washington. This is a big one. And we'll get to, she cites the rules of judicial conduct, the appellate rules, and the rules of professional conduct. All right. So she starts off with an introduction. We're going to skip this part because I think it's more important to get to her actual arguments because, these are getting summed up. So we need to get to the standard review. Okay, so Supreme Courts can review it, and there's no issue there. This court will not issue a writ unless the relator has clear and unquestioned right to relief, and only where the trial court has an absolute duty to act or refrain from acting. So she's merely stating the standards. Okay, nobody disagrees with that. It's just, the issue is this a clear and unquestioned right to relief? And does she have an absolute duty to act? Well, and that's where we get to the issue of what's going on here. Now, her argument is that they failed the procedural requirements for seeking the writ. Now, this is just like the one she filed before where she's like, well, actually, you didn't follow the rules right. And part of that is a valid argument. You didn't follow the procedural requirements. So this court has never issued a writ to reinstate counsel, whereas here, the trial court removed counsel based on the court's reasonable findings. Those reasonable findings were very, very vague, if we remember. You didn't do things right. That was it. That counsel engaged in multiple acts of gross negligence, compromising the accused's right to competent assistance of counsel. And contrary to Relator's assertion, that's Richard Allen's, neither this court and the United States Supreme Court has held that a court may remove an accused selected counsel in only two circumstances: where counsel is not a member of the state bar or where counsel is at an actual conflict. I'm curious to see what they can do that. Relator does not have a clear and unquestioned right to the relief he seeks. Well, you're citing cases. What do these cases say? I'm very, this is where, if you're writing this, you would then put to the end right here, there would be a, hey, there's a couple of cases here, and here's what they say. They didn't do that, and I don't get why they didn't do that. I think it's a little sloppy on their part. To the contrary, this court in State XRL Jones v. Knox County Superior Court denied the relief the relator request here. In State v. Jones, the relator who had been indicted for murder and rape requested a writ of mandamus to reinstate his attorneys, who the trial court had removed. Why were they removed? You're saying something happened, but this is, I think, a problem here. Why were they removed? We don't know why they were removed. And I don't think this is fair. What's going on here? What? What's the deal? What's the deal? Okay, and this is where, when you're trying to write an argument, well, the court did this, but what were the underlying facts? Why did these attorneys get removed? They get caught whacking it in the bathroom. What were they doing that was so bad they got removed? Was it these facts? I doubt it. I mean, there's never an exact set of facts, but what did they do? And they don't tell us. The court denied the petition. In dictum, the court observed that it was generally the view that a trial court is limited in its authority to remove a criminal defendant's important counsel. However, the court finds it necessary to explicate the parameters of that authority here. What happened there? I'm going to have to look this case up. Jesus, I guess I'll do the fucking work. 728 Northeast 2nd. God, I'm going to have to. I got to do some real lawyer work today. Damn it. I thought I was done with that today. All right, let's go. Some of you are thinking, oh, he's probably got Lexis or Westlaw. You don't have that. Fuck paying that much. I mean, I'll go to the law library and use Lexis or Westlaw, but no, I use the Ohio State Bar Association's setup, also known as Decisus, which, from what I can tell, is kind of like a knockoff Lexis. It's like a low version Lexis they sell. But hey, for $13 a month, it is really hard to beat. All right, let's check Ohio. And then I got Indiana. Get rid of Ohio. We're going to grab Indiana. And what was this case number? 728 Northeast 2nd, 133. All right. All right, enter citation 728 and E.2D133. Okay. This is a 2000 case. All right, we are going to share this because here's the case. Here's the case. All right, found it. I hope I'm not breaking the rules by doing this. All right, so State XRL Jones v. Knox Superior Court number 1. Okay, May 10th, 2000. All right, let's see here. All right, in July 1999, Brian charged of murder and rape. Okay, Chucker designated an alternative attorney's move for continuance. The attorneys sought a continuance. The court ruled no DNA would be admissible. Okay. The attorneys filed a motion to reconsider on the alternative draws counsel. The motion began as a mock letter to Jones, which concluded, if you are convicted, you will be without the benefit of effective representation, due process, other protections. Have a nice day. Okay. The motion then criticized the court's order in more detail. Among the motion's allegations, neglects of the parts misleading. The trial court considers the earlier ruling to grant. Okay, so eventually the trial court did grant a continuance. It denied the defense attorney's request to withdraw. It sua sponte removed them from the case because of the insulting and absolutely improper remarks about the court in their motion to reconsider. That's not what we have here. That's not what Richard, okay, great. The court removed someone. That's not what happened here. Court appointed 2 new attorneys and ordered that the attorneys terms their case file. Okay. And the judge also referred their motion to reconsider to the disciplinary council. So those guys were brought up on, she referred them for sanctionable investigations into whether or not they violated the rules of professional conduct. That's not being alleged here. This is a significantly different situation. So this is why this is when you're reading documents as an attorney, when the other side's not providing the story about what happened in these cases, there's a reason why, because they're trying to bullshit stuff and get it passed. Jones sought a writ of prohibition to get his attorneys. He couldn't remove in those circumstances. Okay. So he contended there was contempt and referral to the Supreme Court disciplinary commission, but not removal. Okay. Okay. Okay, so this is it. All right, so this is because Carnahan requested they be allowed. However, the court finds it. Affirmatively requested they be allowed to withdraw if the relief they sought was not provided. It's still a little different here because the court's forcing their hand. These guys withdrew on their own. They didn't. The court did not grant the request, but instead removed them sua sponte. But I've indicated the proceedings have not conducted in the way they favored. We will not countermand the trial court's ruling that placed them in precisely the position their motion indicated their willingness to be. Yeah, this is a little different. This is a little different, I think. Just slightly. And by slightly, I mean whoop, yes. We view our ruling as being a slight variation of the law and standing principle where a party voluntarily adopts a certain form of procedure or agrees in the manner in which its rights are submitted for determination in the trial court. The party will be not permitted to complain on appeal that their ruling as a conformity there with them was erroneous. Well, this wasn't voluntary. This was done under duress. So, yeah, this bullshit case. This has nothing to do with what we're looking at. So, they want to bang that drum, but they're... Still Life is saying, because I'm assuming that's YouTube doing it. So, yeah. Yeah, I'm pretty sure that's YouTube doing that. That's not me. All right, so let's get back to this because now we had to do their work for them, Oh, you got to be... Did I just yeet myself out of that? All right, we're back in the game now. All right, where is it? I'm trying to share. All right. So, yes, to this contrary, State Ex Will Jones denied the relief requested here. That's because this is not... It's not the same case. Once again, it's not the same case. The relator relies for the most part on cases outside of Indiana. Okay, these cases are not binding on the trial court, much less do they impose the respondent an absolute duty to act. That's very true. They are suggestive authorities. They are not binding. but they give guidance that, hey, look, this actually doesn't happen so much. We've had to look outside the state of Indiana, and here's what we found in other courts. Here's how they address this problem done in Georgia. Here's how they address this problem everywhere else. Because this is a novel issue for Indiana, I would argue, probably at this point. When interpreting the Sixth Amendment, the trial court must follow the law of Indiana's appellate courts, yes, stare decisis, and the U.S. Supreme Court. That's all they're bound to do. Relator identifies no case from this court or the U.S. Supreme Court that affords him the clear right to an extraordinary writ for the relief he seeks. Now, I will say this is a hack argument to make as an attorney, but you make it if you're having to fight against this. You say, well, actually, this case has never happened. He's arguing something we've never done before. This is preposterous. It's going to cats and dogs in the streets. You'll make that argument. You will sometimes make that argument. It is a weak argument. It's a pathetic argument, but you got to make it. It's still weak. Holy weak. It's weak sauce. So they have to show why the appeal is wholly inadequate. Far too frequently, they're saying if the relator believes that cases from other jurisdictions are persuasive in how the judge should interpret the Sixth Amendment, she may present those arguments on interlocutory or direct appeal. Well, I hope not on direct appeal, because direct appeal means he got convicted, so I'm hoping it'd be interlocutory. Relator cannot file an original action to circumvent the normal appellate process. But this isn't normal. In Indiana's appellate, as well as other state and federal appellate courts, routinely consider Sixth Amendment challenges on interlocutory or direct appeal, including disputes about removal of counsel. She cites all these, but what did these cases and how did it go down? Because I'm assuming none of these cases, the judge extorted you. Their counsels is saying, withdraw or I'm going to burn this whole fucking thing down. You know, all these cases, I guarantee you none of them are like that. And I guarantee if you win any of these cases, I'm sure if you ask the judges, would you do this? They look at you and say, you're out of your goddamn mind. Notably, relator cites Lotta, Hannah, Harling, and McKinnon in his petition brief, all cases on appeal. Those cases defeat relator's assertion as remedies available by appeal would be wholly inadequate. I don't know about that. I think you need to do a little bit better job there of ascertaining why that is. You should be making the argument about what specific parts, because right now you're not really carrying the banner here. Allen's using an original action, a rule for the first time in Indiana. The Sixth Amendment prohibits trial court from moving counsel where they've been found grossly negligent, but this court will consider a writ only when the law is settled and the trial court's duty is absolute. Okay. Yeah, that's not a very convincing argument, in my opinion. Number two, trial court did not violate Sixth Amendment rights. Sixth Amendment guarantees that you enjoy the right to have assistance of counsel. Okay. The essential aim is to guarantee an effective advocate for each defendant to ensure that a defendant will inexorably be represented by the lawyer whom he prefers. Respondent properly exercised their discretion to protect his right by removing Baldwin and Rossi. As the court explained, does not mean the defendant has an absolute right to be represented by counsel of his choosing. Correct. The appointment of pauper counsel, which is considered appointed counsel, you're pauper, you're poor, is within the discretion of trial court and will be reviewed only for abuse of that discretion. The qualified right to choose one's counsel must be placed against a backdrop of judicial discretion. To be fair, when they represented themselves pro bono, and Richard Allen retained them as pro bono counsel, it's no longer pauper counsel. It's no longer indigent counsel. They are retained. They have signed a contract. They've worked it out amongst themselves. They are privately retained counsel at that point, once they're pro bono. So this idea that they're court appointed, okay, fine, we're coming back. We're getting higher. We don't need your permission for that. They kind of, it looks like they gloss over that here, because it's far easier to beat this drum of, well, if we appoint you, we can remove you. I understand why. They're arguing what's strongest for them. Traditionally, courts enjoy broad discretion to determine who shall practice before them and to monitor the conduct of those who do. My bar card said I have the right to practice and appear before any court in the state of Ohio. If there's a judge out there who thinks I can't practice in front of them, I would argue that judge has an obligation to report me to the Supreme Court Disciplinary Council. I assume that in Indiana, your bar card says the same thing. Their right to practice in front of any jurisdiction in the state of Indiana, governed by Indiana law. So, this idea of the monitor who practices before them, I mean, you might be able to control who's on the appointed counsel list, but you don't have the right to say, like, this attorney can't practice here. I don't think that's a valid argument. The trial, okay, so we're reading through here. Trial court must be given latitude in its efforts to navigate the cilia and sharpness posed by the conflicting Sixth Amendment rights of counsel of one's choice and the complete competent counsel. We conclude the discretion is necessary to create tension because those rights must be resolved by the trial court. Okay, so they cite the Lotta case. All right, good. Gross incompetence or contumacious conduct that cannot be cured. That's an old-timer judge writing that. Cannot be cured by citation for contempt may justify the court's removal of an attorney even over the defendant's objection. Harling citing a case from 1976. Okay. Moreover, the trial court need not delay by taking remedial action when counsel's incompetent representation causes the entire trial proceedings to be constitutionally defective. We must remember that aversils are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception. Fair enough. Now, see here, they do this. This is where you put the quotation or the parentheses. That's how you cite a case and sum it up. This is the United States v. Howard. This is the Reader's Digest. This is Cliff Notes version. It affirmed disqualification of defense counsel on the grounds a trial court has an obligation to foresee problems over representation that might arise at trial and head them off beforehand. Okay. What was going to happen, Judge? You're okay. So you bitched about what was going to happen. You bitched about what happened, not what will happen. So what was going to happen that you were concerned about? What were they going to do? By all means, this is where you can point it out. What were you worried about happening? The respondent acted well within her discretion to remove Baldwin and Rossi over the relator's objections. The record supports a trial court could reasonably conclude Baldwin and Rossi committed multiple violations of the rules of professional conduct. So we're back to this. Well, they may have broken the rules that attorneys have. May have done something wrong. Not proven. There was no hearing. The judge doesn't specifically say you broke the rules of professional conduct either. She says, well, I think you might have, or you should have known this could have done it. Well, either it did or it didn't, sweetheart. So which one is it? This idea, they haven't done anything wrong. And if they did violate the rules of professional conduct, you have a duty to report that. Otherwise, now you're liable under the rules of professional conduct. So I'd be very careful about the water you start swimming into here, Judge Gull. It gets really deep, really quick. But to, on the record, make this claim that I believe they may have committed this, that's a serious allegation. And she doubles down on it. So he compromised Allen's defense and that the totality of circumstances demonstrated gross negligence and incompetence on the part of the defense team. Okay. Baldwin and Rossi failed to take reasonable steps to safeguard confidential case materials and the crime scene photos. Okay. Yeah, we've gone over this one here. This is where Michael Westerman snuck into the office. He took the pictures. He snuck into a place he wasn't supposed to be, took him and leaked the pictures. There's no question about that. So that is not a problem. An individual with whom Westerman shared confidentials committed suicide after police questioned him. Yep. So Baldwin and Rossi agreed to use Baldwin's conference room as the home base for the confidential case materials. They understood that Rozzi understood that Westerman would regularly visit Baldwin's office and would share Westerman information about the case to obtain Westerman's feedback. I don't recall that part, but sure, fine. You're signing the record. I'll assume you're not lying about that part. So Baldwin emailed confidential work product to an unauthorized person, and they timely failed to report the leak to the trial court or prosecutor. I'm curious to see how they're going to thread this needle, but let's see. So in December, Baldwin sent an email to a person named Brandon Woodhouse. Okay. A defendant in an unrelated criminal case that contained an outline of discovery from materials the state had provided to Baldwin. Baldwin apparently intended to send the email to Bradley Rozzi. Okay. Baldwin and Rozzi did not promptly notify the trial court or the prosecution of this leak. See, that's a little interesting because that was just commented that it was his work product. That wasn't very clear about what happened there. Okay. They did not promptly notify the prosecution of this leak. An outline of discovery materials. Yeah, it's like, oh no. Clutch those pearls, Judge. But we're going to take a break here and catch up with some of the chats. Parallax says, calm down, Highlander. Unhung Hero for $2 says, I'm going to come. Don't come. Amateur Iconoclast says, calm nicht. Oh, what? Where did everything go? Jeez. Mr. Squiggle says, I'll do it myself. Yes. Yes. Fine, I'll do it. The GM says, actual lawyer Sean does a fake being a lawyer. He uses the cheapest law website he can. I mean, I get it for free, and it does really good case research. I mean, I enjoy doing the research, so I have no problem digging through stuff. And then, yeah, I will use better, if I feel I need to use other tools, I will use other tools. So, where are we here? Just trying to catch up with all you guys. Sounds like she's throwing Kenny's saying, sounds like she's throwing Hail Marys to discredit the others because she knows she's in hot water. Yeah, this whole thing has got problems. I just don't know. I don't know what the plan is here. I don't know. It's I just don't get it. I just don't get it. Parallax says, I enjoy doing the research. I do, because it's going to sound, well, it probably doesn't sound weird because it's me telling you guys this, so you're used to it. Eventually, you start doing this, or like an appellate work, you start remembering cases, and you start remembering the facts in some of these cases. And every once in a while, you get one or two that you get to burn inside your skull. And then every once in a while, hopefully, you can whip that case out right away. Your Honor, there's actually a case out of the 7th Appellate District, way down on the Ohio River, that says we can do this, and you boom, boom, you hit it through. It's really neat when you can do that. It's like a Rain Man moment. But the researching, I think, does help. You learn the case law, you learn some fact patterns, you learn how other things get handled. Stabby saying the only thing Sean Moore's... Oh, shit, Stabby. I'm sorry, dude. Fuck. My bad. I'm sorry. I'll talk to you. I got to talk to you. I'm so sorry about that. Aaron says, I think Sean is avoiding the poop chats. Of course I am. So we're going to keep going here. We're all caught up now because we're done talking about the poop. So let's get to the rest of this. All right. So Baldwin and Rossi made extrajudicial statements that had a substantial likelihood of material prejudicing the case. I've said this before and I'll say it again. Only one side is entitled to having their case not be materially prejudiced: the defendant. If the defense is able to manufacture enough sentiment that the community does not like the state, tough cookies. That's how it should be if that's how it can be done. Only one side is guaranteed the right to a fair trial. Now, that doesn't mean you cheat and violate the rules and you do all that, but if the community, the state doesn't get to claim a change of venue because it's a hostile, too bad. So, this is a weird way of citing stuff because you're heading, okay, that's a statement, but then you cite your heading. That's just a weird citation thing there. I don't get it, but hey, those attorneys probably make more money than me, so whatever. They can do it. You can do what you want. And, that's the neat part. Do what you want. I do what I want. Baldwin and Rossi issued a press release. Oh, I will say, by the way, the one thing I do love in this thing, there are footnotes. Oh, thank God. I wish all this was footnoted, but it's not. And that's separate. Another issue for another day. I complain about footnotes enough. Baldwin and Rossi issued a press release in November of last year. Okay, about this time last year. In their press release, they included detailed extrajudicial statements about the case. Okay. Along with other information that would not normally be revealed. Like what? Like what? Like what? Like what? Was it information that was already known? And they proclaimed his innocence. You're allowed to do that part. He is innocent until he stands before this court innocent. So prejudicial. Judge Gull, I was taking a tizzy. You mean these peasants think they're innocent before the law? Ha! 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 How dare they? How dare these peasants think that they offer their foot of protection by the law, by this bench in which I preside? How dare they? Baldwin and Rossi did not limit their press release to information that Rule 3.6b expressly permits, nor did they confine the press release to information necessary to mitigate adverse publicity under Rule 3.6c. Baldwin, once again, we get to this thing. They knew or should have known that the press release potentially violated the rules of professional conduct. Does it, though? You didn't refer them for sanctions. You didn't refer them for discipline. So obviously you don't think it did. Maybe they pushed the limits. That's their job. Their job is to be a zealous advocate and to play ball. Their job is to go hard in that paint. Like hard. Like hard. Like real hard. That's their job. More of the time in the press release, Baldwin and Rossi knew the state had filed a motion for a gag order, which is pending for the trial court. Okay. So what? It's pending. Has the court ruled? No. Okay, motions are pending. I can act in court until there's a court order. I'm not I can do what I want. Until the court says don't do something, guess what? You can do that thing. That's how this works. That's why the court issues an order, so you know you can't do that thing. Prior to issuing the press release, Baldwin and Rossi assured the trial court they did not intend to try the case in the media. Okay, well, maybe they changed their mind. I don't know. Baldwin and Rossi's decision to issue the press release prompted the trial court to issue the gag order until further hearing. Okay. Baldwin and Rossi issued the press release knowing the trial court would soon likely issue a gag order. How do they know the trial court was likely going to do that? You cite these record parts here, but until the court does it, I'm not really under an obligation here, but so they knew or should have known, and then, they knew or should have known they were breaking the rules, and then, yeah, they I'm sure they knew what I was thinking. That's where we're at with this. Well, they know. How do you know, Judge? Well, they knew. I mean, how could you not know? I'm sure is what she would say. They knew. These chads knew what I was gonna do, and they ignored me. You got to have more than this. If you think they did something wrong, send them for discipline. You didn't do it. So either it really wasn't that bad, or you're sheltering people who committed discipline, which now puts your ass in the hot seat. I mean, I think we all understand it's probably the first thing. Like, it really wasn't bad. It's just, chapping your ass, which that's our job, is to kind of chap the asses of people. If you're not getting yelled at once in a while, you're not trying hard enough. So we got here, Baldwin and Rossi provided false information to the trial court. That violates the rule of candor. If they really did provide false information, why aren't you sending them for discipline? The trial court held a hearing on Richard Allen's motion to reconsider the safekeeping order of him being sent to prison. At the hearing, the state presented evidence that clearly, to quote Merb, clearly demonstrated the falsity. Oh, now you offer record citations. Okay. On July 19th, the trial court issued an order on the motion to find the evidence presented in the hearing did not support many of the allegations advanced by defendant. In fact, the evidence presented, the defendant is treated more favorably in other inmates' houses at the Westville Correctional Facility. You didn't make any What information was false? I mean, I'd love to see this exactly, because you can include it here. As a result of these events, the trial court became gravely concerned with the rights to have competent, non-negligent representation. The record demonstrates the trial court, based on the totality of circumstances, can conclude that the representation of Richard Allen fell objectively short of the prevailing professional norms, that counsel's deficient performance prejudiced the defense in violation of a Sixth Amendment right. Now, here's the big one. Here's the money shot. Strickland v. Washington. Now, we're gonna pull that bad chicken up, because that is actually an important one here, because that is critical. And this is one where you can you can cheat and go online to Wikipedia for this one. Like, some of this stuff, actually, if you guys are looking it up that way, it actually isn't a big deal. All right. So where we need to go with this is the actual part of Strickland, where it talks about it here. And if you guys are ever trying to figure out what a legal citation means, and I'm actually working on how do you navigate a little bit through legal citations. This is the initial part of it, but then this is the actual where you find the case. Then pages 687 to 688. Okay. So counsel's ineffective where counsel's performance was deficient based on prevailing professional norms, and 2, the deficient performance prejudiced the defense. Okay. How did this prejudice Richard Allen? His attorneys are filing motions saying he's being treated poorly. No, they're not. He's innocent. The state doesn't have shit on him. Telling the press that. How is that deficient? Oops, I sent out the wrong thing. My bad. I sent it to Brandon instead of Brad. Oops. Whoops-a-doodle. And because there's even more to it, though. Those are the basic parts, but there's far more to Strickland than that. There's so we are going to go to the actual part of Strickland v. Washington, so we can actually look at this and see what we've got. So So here we go. All right. All right. We're going to go all the way to the top because this guy took it all the way to the top. So it's the Supreme Court of the United States from 1984. This is the current case that's cited all over the country. This is the gold standard right now. Strickland v. Washington. Now, Strickland is the superintendent of the Florida prison system versus Washington. Washington's the defendant. This didn't occur in the state of Washington. A lot of times I understand you'd see like, Illinois v. Gates or, Miranda v. Arizona, things like that. Matt v. Ohio, Terry v. Ohio. No. This is Strickland v. Washington. This didn't occur in the state of Washington. And it wasn't against George Washington either. To get all the jokes aside, okay? All right. So we'll get to So here's how they start off with, and to get to the standards here, they show that in a convicted defendant's claim that a counsel was so defective as to require reversal of a conviction or death sentence has two components. First, the defendant must show that counsel's performance was deficient. Okay. This requires showing that counsel made errors so serious that counsel was not functioning as the counsel guaranteed by the Sixth Amendment. Okay. Yeah. Are they embodying what they're supposed to do? Fair enough. Second, the defendant must show that the deficient performance prejudiced the defense. This requires showing that counsel's errors are so serious as to deprive the defendant of a fair trial whose result is reliable. So while the judge does highlight that, well, they cause prejudice, you have to show how that would have changed things. Had they not done what they did, that's the second part of element number 2. You have part 1, then you have part 2A and part 2B. You have to show that it would have actually changed things. Because you could show, yeah, it was deficient and it caused prejudice. But was the prejudice, could you have fixed it? Like, for example, Nicholas Cruz, the Parkland shooter. Let's say he went to trial and his attorneys fell asleep in the middle of it. Was that going to overturn things? Had they stayed awake, would that have changed it? No. The court would say, no, he was still... Now, should they say, yes, your rights were violated, you shouldn't get another swipe of the apple? Yeah, you should get a new trial. Your rights were violated, period. But as we talk about, appellate courts look for every way to get around it. And some of you might look at this and say, the second part here looks like harmless error in a lot of words. And it basically is. A trials whose result is reliable. Here's the thing. They point out that it's reasonably effective assistance. Okay, well, what's reasonably effective? I would argue these guys are doing reasonably effective work. They're going above and beyond it. So this entire thing is a bunch of garbage from the judge. Critterville, how are you doing? Good to see you. Forum, how are you doing? Good to see you too as well. It's been a while. Oh, David, over on Making Law Simple, saying, is this Judge Lucid? I thought she was in a coma or something. She's in the hospital. She's in the hospital for something. Something happened. I don't know what. I'm sure it's, if I had done all this, I'd be looking to hide as well. But let's get back to what we're looking at here, because that's the only thing I don't like. StreamYard does not, if you're trying to go between windows, it's one thing. And if you're going in between Chrome tabs, it's not a problem, but it needs to be, wish there's a better way at that, but whatever. So yes, the deficient performance prejudiced the defense. Remember though, there's this other part of here, like that it would have actually mattered. So you notice we're saying some things, but we're not saying everything. The professional norms in Indiana are violated when counsel fails to safeguard confidential materials, provides false information to the court that you did not refer to disciplinary counsel for. So was it really false? Or was it just incorrect? I mean, you're accusing them of fucking lying right now. You're accusing them of lying and not being candid in front of the court. That's a big, big deal. And making extrajudicial statements are likely to prejudice the case. Who cares? It's their job to go out there and fight for their client. And here, now this is the judge saying, I'm reacting along with you guys right now. This is a gem, and the respondents filing complaints against Baldwin and Rossi with disciplinary commission would not have ensured that relator would have received competent representation throughout the remainder of the proceedings. Really? That's your answer? That is a cop-out of, that is the cope of copes. Well, I didn't report him because it wouldn't have changed anything for the defendant. So are you saying that they did violate the rules or they didn't? Because if you reported them, and I think they did. Do you really think they did? Because if you didn't, you wrongfully and intentionally and maliciously reported them, well, that is a violation of the rules itself. So I know there's a reason why you didn't refer them to disciplinary counsel. We all do at this point. Because they weren't breaking the rules. We know they weren't breaking the rules. And David, if you're still here, I will send you a link if you want. Hold on. Let me get the Twitter DMs going here. All right. Got the StreamYard linkification. All right, we're going to get back to this now. So here we go. We're going to keep going here. The trial court's decision to remove Baldwin and Rossi did not violate his rights. Okay. The trial court afforded realtor Richard Allen adequate notice and an opportunity to be heard before removing his counsel. You did? This was a drumhead court martial. There was no time. They did not have a chance. Relator argues that the removal proceedings should occur at a hearing where the defendant and his chosen counsel are provided notice and opportunity to be heard on why the relationship should be severed. Yes, the principle of due process. Yes, Judge Honey. That's yes. We have that thing. This is America. Childish Gambino's song says, this is America. I know he doesn't mean it that way, but yes, this is America. And God dang it. Killing me. I'm going to get a better PDF set up. This is just driving me up the wall. I need a better one that doesn't suck. Because I can't do this anymore. So, yes. You're not the idea that I'm going to remove your attorneys from this case. Well, I'd like to have the opportunity to contest that. Pretty fair. I think we'd all agree, like, hey, we should be able to do this. Excuse me, but I thought this was America. I thought so too, guys. The relator cites no Indiana rule, statute, or case requiring notice, a hearing, or an opportunity to be heard. I mean, is the judge arguing under Indiana law? She can just sit there and pick a case and be like, yep, you're gone. I get a notice hearing faxed to me. Yeah, you're removed. Or I get an email notice the filing's been done. E-filed. Yep, you're removed. Disqualified. With no right to be heard. Just that a defendant can just, oh, you got a new attorney. How? Boom. Out of nowhere. This idea that there is no opportunity or notice to be heard, I'm sure because it happens routinely, people do have the right to be heard, and no court's ever been told, hey, dummy, you can't do this without a hearing. I'm pretty sure that's like, I love those arguments of like, well, there's no rules about it because nobody was ever this stupid. Nobody ever, I guarantee you, nobody prior to this case would have said like, oh, judges are going to do all this. No, that's not going to happen. That's crazy talk. That's the problem here. The crazy talk happened and nobody was prepared for it, but I don't blame the court for not being prepared. Why should they be prepared? I mean, this is absolute insanity. This is absolute insanity here. In any event, the record confirms that the respondent provided relator with ample notice that the trial court was considering disqualifying Baldwin and Rossi before October 19th of 2023. Through his attorneys, he had a week, and it was never confirmed because remember, this was that whole thing they had over the phone where they were told to stop working. Nothing else is established. And this is that phone call that was off the record. We don't know anything about that's out there. And Zavin's right. Yes. Nobody told me I couldn't draw on the walls of my own poop. There's no rule against it. I don't see it anywhere. Right. This is basically what the judge is arguing here. So this just keeps going. In any event, yeah, so they had a chance to prepare. They didn't know what was being accused of them. They didn't know what they were being accused of. They never got formal notice. Just then, other than just saying, you're bad, you're gone. On October 11th, Allen wrote a letter to respondent requesting that his attorneys continue to represent him and acknowledge that the prosecutor was seeking the disqualifications. On October 12th, Rossi wrote a letter to the judge saying why he should not be removed. Okay, and on the morning of the 19th, the attorney representing Baldwin filed a memorandum regarding possible disqualification and sanctions. Yeah, they were literally throwing darts at the wall because they didn't know what was going on. They covered their bases, which is what you try. If you don't know what's going to happen, you do the best you can. The fact they were filing a scattergun demotion to nail everything down is an example of the court not providing notice. There was no formal motion pending. The state didn't seek anything. The court had made no notice. So what are they supposed to do? How do you respond to a motion that hasn't been filed? You really can't. The relator had adequate notice and opportunity to argue against respondents' disqualification of Baldwin and Rossi. So this is where I'm curious to see what the judge is arguing, that she thinks that Richard Allen should have argued why they should have stayed. He should have gotten more counsel. How is he going to do that? Is he going to get more counsel? You've already appointed counsel. Are you going to say, Judge, can you appoint me more counsel to help protect my other counsel? She's not going to do that. He can't get more counsel that's out there. He can't hire them. He can't do it on his own because the judge is going to strike it down and say, no, that's hybrid representation. You can't do that. So this is the argument she's trying to make here are awful. Baldwin and Rossi also had the opportunity to proceed with a scheduled court hearing, but chose to withdraw instead because you were extorting them. And for them to do so would have been a violation of the rules of professional conduct. And you're talking about prejudice and incompetence. That would have unduly prejudiced Richard Allen severely. Because who caused that to happen? You did. Well, the defense attorney didn't. They left on their... The defense attorney withdrew because you threatened them. This is absolute insanity here. You know, they could have let me ream them out in court, but they quit. Listen to that. Listen to that language. You could have let me beat you, but you ran away. You didn't let me abuse you, so now it's your fault. I mean, listen, the temerity of this woman. You know, Judge Gull, you've got some gall. I'll say that much. At the October 31st hearing, Baldwin and Rossi further argued against their disqualification after filing new appearances in the court afforded them an opportunity to be heard on the record, including via Baldwin's counsel. The trial court afforded the relator adequate process. Did you really? You denied him on one situation, but you gave him another. You didn't let him do it before. So now let's get on to some of the other stuff here. That is, request for the court to show order the disqualification fails because there's been no bias or prejudice toward him, his current counsel or his former counsel. First, she claims that because he removed the attorneys, that's not a valid claim. Baldwin and Rossi no longer represent him and does not assert that they have any personal bias or prejudice towards himself or his current counsel. Second, on the merits, Allen presents no relevant facts supporting the assertion that the respondent is biased or prejudiced against the former counsel. I think there's a massive issue of competency, and I think it's a bigger issue here. So let's get to what she argues here, that a law presumes the judge is unbiased and unprejudiced. Very true. Judges are presumed impartial and unbiased. Yep. Nobody's questioning that. The respondent removed Baldwin and Rossi from representing Allen on October 31st. The respondent appointed new counsel, Robert Scremin and William Robrato, who one of these guys is an attorney who already commented on Richard Allen's case, rather not in a positive way. So I understand why she appointed attorneys who have made comments already to the press and have been used as commentators on it. Seems a little incompetent to me. What do I know? I'm not a judge. I'm a simple attorney folk here out in Ohio. The relator is represented in this original action by Mark Lehman and Kara Weinke. Those are from the public defender's office. Allen accuses the respondent of exhibiting bias or prejudice exclusively towards Baldwin and Rossi. I think she has been. The relator never suggests that respondent is biased or prejudiced against the relator or his current counsel. Given that Baldwin and Rossi are no longer counsel of record, his sweeping assertions that for all rulings going forward, the public will question the judge's impartiality and a new special judge must be appointed to restore the public's trust amounts to blind speculation. Is that like speculation where you think somebody may or may not have violated the rules of professional conduct? Or you think they did something wrong, or you feel they did something wrong? You mean that kind of speculation? That kind of speculation, Judge? You know, like I said, I'm Ed Sheeran here. I'm just thinking out loud. That's just me. That's just me. Like I said, what do I know? What do I know? So, Anna's saying, here, Sean, Judge Gull has a problem. Yes, I think so. Yes, Parallax is a losing battle with the microphone. Thank you, Parallax. Appreciate it, buddy. D. Marie says, meanwhile, the prosecution was there ready with witnesses. Yeah. Yeah, that's the funny part. They knew what they were going to do, which I think the Richard Allen's attorneys were right not to bring it up, but I bet there have been ex parte communications. That's what I would infer from the entire situation. Aaron saying I don't look like Ed Sheeran. I know, but I'm just like Ed Sheeran. I'm thinking out loud. But yes, that's speculation, Judge. You're worried about the speculation. I know somebody who's been spitting a lot of speculation the past 19 pages. You know, somebody named Frankie. I know somebody who's been spitting a lot of blind speculation. And, the public will question this judge's impartiality. Yeah, I'm pretty sure a lot of people are questioning Judge Gull's impartiality at this point. I'm betting a lot of people are. Even if Baldwin, so going on, even if Baldwin and Rossi still represented relator, the respondent has exhibited no actual bias or prejudice against them. The relator offers a scant 2 sentences to support his assertion that she's exhibited bias or prejudice. According to Allen, Gull's finding counsel were grossly negligent, publicly proclaiming she had grave concerns about the representation warranted disqualification. A judge's findings adverse to a party do not or even imply bias or prejudice. They can, though. They can. But yes, the idea that merely because I don't like this, the judge rules against you, doesn't mean they're biased against you or prejudiced against you. But in this situation, I think it's pretty easy to figure that out. Further, these findings do not demonstrate actual personal bias. Respondent did not state she had grave concerns about Baldwin or Rossi personally. Rather, she had concerns only about the representation of Allen and his right to competent representation. You know what would have helped a lot here, Judge? Developing a record. Properly developing a record. Doing a hearing where notice was provided. And parties had a right to due process. Not cutting corners and just showing up right before a hearing and saying, quit or you're fired. And making a spectacle out of a court hearing. That probably would have helped here. But we didn't do that. Why? Well, there's only one person responsible for that, and it's not me. And since Judge Gull's not watching this, I can say it's probably nobody watching this currently. Something to think about. Respondent's legal findings regarding Baldwin and Rossi's representation are insufficient to overcome Indiana's law presumption that the respondent is unbiased and unprejudiced. Yeah, but like I said, I still have a competency question. The court should deny the request to reinstate the trial date. Relator requested the continuance. No, his counsel did, not him. Allen requests the court to reinstate the January trial date. But Relator's counsel, yes, the counsel you appointed and forced upon him. Notice that. What she does is talking out of both sides of her mouth. Oh, well, he did it. Well, no, his counsel did it, but I want him to do things. Notice they're bounced back and forth between these. And some of you might be thinking, that's not clear. That's the point. It's meant not to be clear. Requested the trial continuance because the counsel will not be ready to try the case in January. Respondent did not violate an absolute duty by granting relator's own motion. And see, this is how you know they're playing the game. That's how you know they're playing the game here. That is the problem. This crap she's doing right now, and I wanted to bring it back up so you can look at me right in the eyes. That's how they're playing this game. It's absolute bullcrap what this judge is doing, and it's this is a sketchy argument. I don't like it. I don't like how she's running back and forth. Jumble Dunce has a special live stream, but no Rumble. This isn't like a super huge one. I thought this was We'll get this one done and it'll pop up on Rumble. But yeah, this I don't like how this is being presented. This is this is just not good. I don't think this is fair. So it's just absolute garbage. Absolute garbage. I mean, this is once again the temerity of this argument that's being presented here. The temerity of this argument. Is just oh. So this is just absolutely all right. We're going to use Chrome instead. We're going to see. Screw you, Adobe. Maybe I'm jumping right now. We'll see how this works. The respondent did not violate an absolute duty by granting the relator's own motion. Yeah, this right here. This right here. This is just garbage. This is just garbage by the by the judge. The court should deny the amicus request for refer to appointment of replacement counsel to the state public defender. The trial court's current counsel is procedurally defective. Relator raises no objections to respondent's process before appointing new counsel to replace Baldwin and Rossi. Amicus may make arguments in support of relator's request for relief, but this court should not entertain their request for relief. Okay. Neither the Indiana Public Defender Council nor Allen assert that Allen's newly appointed counsel, one of whom, as the IDPC notes, is Allen County's chief public defender, is incompetent. The IDPC merely claims that the trial counsel circumvented the county's comprehensive hand for public defender assignments. However, the trial court has discretion to appoint counsel other than counsel provided for under the board's plan when the interest of justice require. Okay. The trial court's method of applying counsel did not violate Indiana law, Sixth Amendment, or any absolute duty under the law. Okay. And then the judge is done. So, Robert Gouveia just wrapped up. Oh, good. So, yeah, this is DeZoon saying this judge is in the hospital for going pants on head, I don't know why the judge is there, but I'm assuming if I had done some embarrassing crap like this, I'd be looking to crawl into a hole too. Rob is a good boy. Oh, Rob's great. I love watching Rob's stuff. It's very good. Women shouldn't be judges, not even Judge Mommy. Jesus. Oh, we're not going down that road. We're not going down that road. D. Marie says, what is your end game in all of this? I don't know. Like I said before, I mentioned it a couple times. I mentioned it with Eric Hunley. I don't get what her game plan is in all this. I really don't. I don't know what the game plan is. It just doesn't make any sense to me. I just I don't get it. it's weird. It's weird. It's going to be interesting. I really hope the courts get involved, but I'm still worried that they're not going to at the end of the day. And we'll see what happens from there. But yeah, this is just absolute absolute garbage. Personally, I mean, I think that's where we are. Like, I don't know how they can, take a look at all this stuff, all of this crap, all of it, and they're going to be like, great idea. I don't know. I'm going to get to that in a second. She's operating quantum level chess. Yeah. It's a shame. That's a shame. How you doing? Hope you're doing well. Hope you're feeling better. Said that's some fuck shit. That's what it is. It's by France repeal the 19th Amendment. Yeah. Kenny says, how long do you think it'll take the the Indiana Supreme Court to rule on this? I don't know. I assume pretty quickly. This is a pretty important issue. Even they've got to know this is kind of something they can't screw around with too long. So I have a feeling pretty quick. I mean, we'll know probably, I think within the next week or within 2 weeks, I bet we know. Probably sooner, maybe this week. I wonder if there's going to be, I don't know. I mean, the Indiana Supreme Court could order oral arguments on this possibly. I don't know if that, I mean, that's not normally within their rules more than likely, but they could grant that if they wanted. They're like, look, you guys need to come in and lay this out for us. I don't think so. I think they'll just do this on the merits of the briefs that have been presented. I would think, like I said, within 2 weeks, we'll have an idea because they're not going to want this to drag out too long. This is a criminal case. Speedy trial's an issue. This is an entire mess. I'm sure that they're looking at this thinking, oh my God, this is a dumpster fire. We need to get this sorted out pronto. So I'd like to think within the next 2 weeks, if not sooner. But maybe I'm wrong. I don't know. Could the case be really weak and the judge knows it or something? I listen, I don't think there's some sort of massive conspiracy here. I don't think that's the issue. There's nothing there. I get it. People like to think there's, you watch enough things on Netflix, there's conspiracies under every tree. And, this goes into the halls of power and we can't tolerate. Ain't none of that. I really doubt it. Life is never that cool. As much as we'd like to think that's how cool life is, it's never that way. So, no, I don't think there's anything like that. I just think she's stupid. I just think she's not doing a good job at this. What kind of punishment, if any, would be applicable in the situation? There wouldn't be a punishment necessarily. They'd just say, let's say Richard Allen got everything he wanted. There'd be a writ of mandamus or mandamus or mandamus, however you wish to prefer to call it. And the Supreme Court of Indiana would say, Bradley Rossi and Rossi and Baldwin, you guys are back on the case. So the writ of mandamus would be approved, and then the writ of prohibition would be Judge Gull, hit the bricks, you're gone. That's all it would be. You're done. You're relieved. She'd be relieved of her duties as special judge, but she'd go back to being the judge over in Fort Wayne. It doesn't remove, that's, not a big deal there. Dell says, could she get disbarred? No, none of this has risen to disbarable conduct. I mean, that is the death penalty. Suspension of her license, nothing like that. She's not even eligible for a sanction here. She's an idiot. I mean, but that is far from any sanctionable conduct really at this point. I think I've said it. I said it on Friday. Certainly her conduct here is going to be studied at judicial conferences for decades to come as an example of what not to do. But no, none of that's going to happen. That's a shame. Says if they give the judge's discretion to indiscriminately DQ PDs, I fucking quit. Well, hope you don't quit. Fair Frozen 55 for $2. Thank you. Saying, am I continuing the show in locals or is this today's show? So here's the deal. If you guys are new, we do a show over on potentiallycriminal.locals.com. Locals is basically like Patreon, except it's far better. And the environment it fosters, there is no, you're allowed to do what you want. Over there, every Monday night, starting about 8:30, I do a show. We go for a while. We talk, hang out, and have fun. That will be happening tonight around 8:30, 8:45. So you guys can go to potentiallycriminal.locals.com. You guys can come in. If you want to become a member, that's free. If you wish to be a supporter, it's $3 a month. If you buy 10 months, you get 2 free. If you'd like to instead just put your toe in the water, just a little dip, you just want the tip, put your tip in it, you can use the promo code CRIMINAL for 1 month free access to everything, including the live streams, which we'll be doing tonight. Those are a little bit different. We talk about all kinds of things. So you guys are welcome to do that. So we are still doing it. I know Parallax, you asked it as well. Yes, we are going to be doing the local stream tonight. Just wanted to make that clear. So there you go on that regard. Cedar Rose had to double check it wasn't Thursday. Yeah. Parallax says, is she elected or appointed? Indiana does elections. So this will be that's an example. People in that area going to have to see. This is the kind of judge you want. RP says, but Turtle Boy said everyone's part of a conspiracy. Very true. Very, very true. Zaven saying, if this is actually a good question. If they rule against her, would that give the future attorneys? We're going to wrap it up, guys, on a couple more questions because then I need to take a break and get ready for dinner here. Zaven saying, if they rule against her, would that give future attorneys appearing in her courtroom leverage to make arguments against her loopy behavior? No. I mean, they would have to base it on the stuff in front of them. They can't just say, oh, she made some goofy stuff here, so we can say she's goofy everywhere else. Now, if she's doing that, and there's a pattern and behavior of that, okay, well then, yeah, that can be a problem for her. But for right now, no, this is not going to give them any ammunition. So, what's for dinner? I don't know. I can smell it, but I don't know what it is. Goalie says the gay frogs got to her. Scam Likely says the writ of Mandamus. Maybe I'll make something for maybe I'll make coffee mugs with that. The writ of Mandamus. That'll be funny. So let's see here. Dazoon saying, I think she was just so pissed off at the handling of the evidence she wants any excuse to jettison the defense. I mean, certainly she might be mad about how it's going, but you don't get to do it that way. You don't get to do it that way. That's as we learned, as Walter says, this isn't Vietnam. We do have rules. Vodka says not doing the Nick dinner and just drinking a bunch of whiskey. I couldn't do that. I enjoy food too much to just go on a liquid diet. Oh. So, what's this here? I made a bet that if Zelensky asks for more money today, I do an all-night stream, but I $20 the bet. Yeah. Yeah, every day that ends in Y. So, all right, guys. Well, that is it for now. I just want to thank everybody popping in here. This is a little more impromptu. I saw it and I was finishing up some things, and then I thought this is important enough. We should go over today and not hold this out till Thursday. So, once again, guys, I'll see you over on Locals. Remember, potentiallycriminal.locals.com. It's free to become a member. You can sign up for free. It doesn't cost you a dime. And then otherwise, we will be going live Thursday night at 9:30. And tomorrow I have a video uploading of a woman, woman giving the police a bit of her mind with her one finger. And it's actually pretty funny, I think, how we cover it and how I break it down. So other than that, I will see you guys later tonight. Have a great night, everybody.